Hello, everyone. You have entered the webinar as a mute attendee, but Zoom features a Q&A tab where you can ask any questions during the program. We'll collect them all and answer either live during the webinar or afterward by email. And now, after a brief introduction, we'll proceed with today's webinar, co-sponsored, as always, by the University of Florida 11 College of Law Institute for Dispute Resolution. Lance?
Good afternoon, everybody. My name is Lance Harke. I am a proud member of the UWM Center for National Class and Mass Actions, and we're delighted to have everybody here this afternoon. Thank you all for being here. I'm really excited because we have a tremendous panel to talk about expert tips for settling class actions in 2026. And I can't think of a more expert panel than the people that you see in front of you right now. Let me just briefly introduce our panelists. First, we have Rodney Max, who leads our class action and mass torts practice, which is a national practice at our Center for National Class Actions. Rod, thank you for being here. Rod's been a mediator for decades and one of the most distinguished and well-regarded mediators in this country, particularly for class actions, for probably more than 10,000 mediations now, Rod, or maybe more. Thank you for being here.
Sure.
Judge Proctor has been on the bench as a federal judge in the Northern District of Alabama since 2003. He's presided over many significant cases over the decades of his service as a federal judge, including most recently the Blue Cross Blue Shield MDL, which is, I believe, in the process of being resolved before the judge. Thank you for being here, Your Honor. Thank you always for all of your educational and outreach efforts that you've done for us over the many years. Thank you.
Thank you for having me.
I'm really excited to have David Selby present to share with us his thoughts on settling class actions. David is the practice group leader at Bailey Glasser, which has a nationally recognized mass torts practice and class action practice. He's one of the few class action litigators who has actually tried class actions to verdict. And so we're excited to have David here and share his perspective. And last but certainly not least is my old friend, Frank Zacherl, who's been a longtime partner at Schutz and Bowen and a member of the South Florida legal firmament for decades. He's the leader of Schutz and Bowen's class action team, and we're grateful, Frank, for you being here to share your many decades of expertise and experience on how to resolve class actions. So that's our panel.
Thank you.
Let's go ahead and take a look at our topic, which is expert tips for settling class actions in 2026. And what we're going to do first is talk about, well, let's go to the next slide. So these are our topics for today. We're going to talk about some of the current trends in class action litigation, what the national landscape looks like today. We're going to talk about building settlement relationships among the parties, and that's a different exercise than the litigation relationship that already exists between parties and lawyers. We're going to talk about some mediation techniques that are effective, both from the mediator perspective, from the practitioner perspective, from the judicial perspective. Then we're going to talk about settlement structures and how those structures can be formed, when to form them, what the right way to do it is. And then finally, we're going to talk about some ethics and class action approval issues, including the timing of attorney's fees and payments and things of that sort. So that's what we have on the agenda for this afternoon. Let's go ahead and take a look at the first slide. Okay. We're really fortunate to have our panelists present here because they can hopefully share some guidance on what the class action landscape looks like today. And I can just tell you from my own 2 cents, my own perspective, and this is borne out by the data, that we've seen over the last several years, more filings, more class action lawsuits. We've seen an increase in the complexity of those filings. The timeline for the settlement of many of these more complex, larger class actions is longer. That we've also seen in some instances greater judicial scrutiny of some of the aspects of the class action settlement process. But I'd like to start by asking our practitioners, David and Frank, I mean, what have you guys seen in terms of the current state of class action litigation, what the landscape looks like?
Well, there's no question that there's been an increase of filings, both statutory remedies, branding remedies, and an assortment of consumer items that come out not only from federal statutes, but state statutes. And what's interesting with the increase is the involvement, A, of the federal courts, and B, of the evolution into and to the state courts. That is, where federal courts may not be as compatible with the issues that people are open to, and state courts are receptive of taking on the jurisdiction of these class actions as well.
David, what's been your experience with current cases that you see in the national landscape for 2026?
Yeah, so I think, and this is probably pretty consistent with what everybody, has seen, and what the courts are seeing. Obviously, the consumer protection issues, the AI and emerging technology trends, the securities class actions, the data privacy and cybersecurity. I did some digging, and we were talking about this earlier, and I thought it was very telling, if you will, that for 2025, like 1,700 class action settlements, total of $79 billion, nearly doubling, I think, from 2024.
Wow.
And so what I have seen, as especially in our role of getting brought in as co-counsel, and a lot of when people come to us with theories, etc., what we're seeing more and more is this excitement level, if you will, whether it's a right or wrong, because the plaintiff's bar sees this, right? And they think that, hey, why is there so much activity here? So because of the trend, part of that trend, quite frankly, has attracted, a lot of talent to the plaintiff's bar that has not necessarily been in the class action space.
Mm-hmm.
So that's one trend we've definitely seen over the last 3 or 4 years.
Mm-hmm.
Firms that are immensely talented that, 5 years ago were not doing class action work.
Mm-hmm.
So that's one, interesting trend we've seen.
Frank, what about from the defense perspective? What have you seen?
Well, to echo what David was just saying, when tort reform came through here in Florida, the tort lawyers started looking around for something else to do. There were fewer opportunities to file tort cases, and the cases that you filed were tended to be harder to prosecute. And so one of the places that they trained their guns was in the class action space. And so we have seen just an increase overall in the sheer number of class actions. If you see the daily suit reports, every day there's a half a dozen new class actions that are filed, many of them in federal court. So that's one thing that we've seen is just an increased volume, at least in Florida, probably attributable to tort reform. But the other thing that we've seen is what David was saying about the new players. We have plaintiffs' lawyers who are getting involved, who are extraordinarily talented in whatever they did before they started doing class actions, very bright, very experienced, and bringing the new novel theories that we have not seen that much before. I've worked with some of the folks on this panel in real estate class actions in Florida involving the Landlord-Tenant Act, which is a fairly new phenomenon. And what happens as a consequence of all of this new life and energy is that all of a sudden, under the commercial general liability policies, there's now insurance for a lot of these cases.
Right.
For example, in the TCPA space, you haven't been able to buy a policy in many years now. But when we're talking about real estate class actions, for example, these commercial general liability policies will provide coverage. And so what happens is they will hire one of their panel counsel. And in many cases, those panel counsel don't specialize in class actions. They don't have experience in class actions. And so what happens? You have a plaintiff's lawyer without very much experience. You have a novel legal theory with a lot of case law that hasn't really been evolved. And you have a defense lawyer who doesn't have very much experience in class actions. And, you know, the chaos that ensues has been very, very interesting to watch.
That's a really interesting point. You also see that in the mediation context where you know where some of these newer players in the field require a certain amount of getting used to the field, getting an understanding of how the practice works, how the players operate, and how things are done. An interesting statistic, Frank, did you see in the most recent Carlton Fields class action report, the spending is defense spending close to $5 billion just for 2026, and it's gone up and increased every year.
Yeah, I did see that, and it doesn't surprise me at all because of what we're seeing, which is this increased volume in this space. And for all the practitioners out there who are listening, the best advice I think any of us can give you is if you get one of these cases and you don't have the experience, associate someone who does, because there are a lot of moving parts in class actions. There are a lot of ways that you can screw up, but there are also a lot of real opportunities for your client to get rid of very significant exposure for very minimal amounts of money. So I can't say enough how important it is to have experienced counsel involved.
Frank, I'd like to seize on that real quick, and that is not only is it the experience, but in this space, the relationships are key because it's a national fraternity sorority of attorneys from all over the country that have done this before, have done this against one another, with one another, and the value of the relationships they have built opens doors that would not otherwise be open other than through formal things going on in the court or with discovery.
Definitely.
Let's go ahead and take a look at I think that's a perfect segue for the next slide, which is exactly that, Rod, which is, building settlement relationships that lead to a resolution in the class action context. And, it's a different relationship because if the parties are able to successfully settle, they have to file motions for joint approval and they become, in some sense, aligned with the ultimate outcome, which is to, see the case resolved for all the reasons that Frank and David have articulated. So, Rod, why don't you tell us how we can help the parties build a settlement relationship that could lead to resolution?
Well, it starts early. And of course, from a mediator side, it can't start until you get hired to do it. So from that standpoint, without interfering with the discovery that's going on, many times mediators can help manage, initiate, and open doors that aren't otherwise there, or the formality of discovery can be become an informal process and an exchange that can be expedited. So the quicker a mediator can get in, start beginning to have dialogue with one side and the other. Yes, maintaining confidentiality where it needs to be in place, and yet extending it where it is appropriate to let the other side know some of the things going on the other side. The sooner we can start building the bridge, the quicker the parties can begin to expedite substantively their relationships and their roadmap, because these cases are not just about a number. They're about a number fitting in a structure, sometimes more complex than others, certainly not a number that has attached to it non-monetary aspects that have value. And so from a mediator standpoint, beginning to help manage that is something that will help the parties.
Judge Proctor, as someone who oversees the process of class action litigation and resolution, is there a role for the courts, to help get the parties into a settlement posture at an early stage, and so they have an opportunity to evaluate what the merits are of the case, what the strengths and weaknesses are? Is there something courts can do to encourage these settlement relationships?
Absolutely. Now, in a class action context, the court cannot, in my view, be involved at the same level they may be able to be involved when all the parties are there before the court, when there's not absent parties or class members. But nevertheless, and the reason for that is ultimately the court's going to have to make a determination about fairness, adequacy, and reasonableness of the settlement. And more judicial scrutiny is being placed in those areas right now. We had a subject matter a moment ago that said greater judicial scrutiny. I think that's absolutely right for several reasons. One, the age-old reasons that we have absent class members that have to be protected, and class negotiations are always subject to potential collusion. Plaintiffs want money, defendants want peace and prosperity and finality. Class reps might want service awards, except maybe in the 11th Circuit. So that's a problem. But more recently, the 2018 amendments call for greater judicial scrutiny. And that sits in juxtaposition to the court being involved too heavily in the negotiation of the class, because there's greater responsibility the court has to determine under Rule 23 the appropriateness of the class, the appropriateness of the consent decree. I don't think anybody's going to feel great about Judge Proctor determining that a provision he suggested and prevailed upon the parties to adopt is fair, adequate, and reasonable. So that gives you a concrete example of why I think the courts have to be somewhat careful. Now, what can we do? We can direct parties to go and negotiate. We can, and I always tell folks in a class action, if you're going to be negotiating, you need to go get a mediator, because I want the mediator to be able to tell us that this was an arm's length negotiation. It was not a reverse auction or something along those lines, that the proper order of operation was followed. The class relief was negotiated fully before we got to things like fees and expenses, and a host of other problems that could pop up. A great seasoned class mediator helps navigate the parties through those obstacles.
Judge, can I ask you if in your standard CMO, your case management orders, do you have a early mediation? Do you require the parties to pick a mediator early, or at what point in the process do you?
So in the standard scheduling order, I require mediation by a certain date to notify the court. Now, not necessarily in a class. In a class case, I think that's much more nuanced than just sending them out the door with that requirement. I think early on, we engage. So Rule 16.1, which is, I chaired that subcommittee, and the rule became effective December 1. One of the menu items is discussion about resolution potential. And so in the class context, I think early on, ask the parties what they're thinking about that. Ask them if an early appointment of a mediator would be beneficial. Sometimes there's objections when the parties have an agreement 95% done and bring the mediator in as the closer. I think it helps to have a mediator involved early on. And one of the things in big cases, I'll ask the parties, have you thought about designating separate settlement counsel? This is going to be hard-fought litigation. Rod made a great point earlier. This is all relationship driven in a lot of ways. Frank and David might tell you that if they were off punching each other in the throat last week, it's kind of hard to crack the door open to, hey, how are we going to beat the swords into plowshares? So not in every case, and in some cases, it doesn't make sense to do that. But in certain cases, it makes absolute sense to do that.
Lance, let me echo on that one comment by Judge Proctor, because this is an underappreciated aspect of a nuanced aspect of being a class action practitioner, particularly on the defense side. The first time I ever got a call, which was 20 years ago, from a client saying to me, listen, I want to bring in another attorney to help negotiate a settlement, I said, that makes a lot of sense, and got off the phone, and my ego was bruised, right? Because I thought that was an indictment of me. And actually, it was exactly the opposite. The war had been fought so hard, everybody was at each other's throats. It would have been very difficult to have a meaningful or productive settlement conversation, because the litigation wasn't advanced far enough where anything was resolved, and we had staked out our positions. So having this new lawyer come in, who ended up being a lifelong friend of mine, was the best thing we ever could have done, because we got the case done right away. So if all you defense lawyers out there that are listening, if this happens to you, don't take it personally. It's actually exactly the right thing to do, number one. And number two, you may want to suggest it to clients in certain instances. So sorry to interrupt there, but I wanted to make that point.
That's an excellent.
And I would add, Lance, but so I to exactly what Frank and Judge Proctor were saying. First of all, I think having the mediator in at the very start, in the very beginning stages, is so much more important in the class action context than any other. And for this simple reason, the amount of non-monetary terms that have to be negotiated in a class action are just immense. And you can't think as a plaintiff practitioner, I'm thinking at the end of a number based on the class members I potentially have here, and based on the damages, we've calculated with our experts. You got to be thinking there is so many non-monetary issues that come even before that, that having the mediator in very early, an experienced class mediator who can say, have you guys thought about this on your, before you do your releases? Have you thought about this on your reverters? All the different things that go into that. So I echo everything that was just said, even with the emphasis of from the very start. I mean, just have somebody. You're not going to get questioned on collusion. You're not going to get questioned on anything, because you've had somebody there the whole time. And
David, can I ask a question? And I don't want to take over Lance's role because he's better at it than me. But
I was just going to say, you're way better, Judge. Go for it.
We've seen instances where the general counsel has said, all right, we're going to have a litigation team and a settlement team. And the old war stories about the settlement team walks in on the eve of a key deposition, says, pencils down, we got the case settled. Do you think there's avenues where plaintiff's counsel should consider? You don't have general counsel directing you, but would it make sense to have somebody in your firm, or even someone outside your firm, to join the team and work on that in certain select cases?
So the answer is absolutely yes. In fact, we were talking about this, Frank and I talked about this some, and I was telling Lance as well, and that is, we recently, the last 3 to 4 years, one area we are being brought in as trial counsel for the class case. We don't step in the way of what settlement negotiations are already taking place. We don't step in the way once, for example, a verdict in a case we got last year, a favorable verdict on a class action. The counsel who brought us in continued those negotiations after the verdict, and we're bringing that to a head. But we didn't stick our hands into that space. We let them continue to negotiate. We did our part on the litigation side. It works out really well. So yes, to answer your question on the plaintiff side, I think you'll see more and more as the stakes get bigger and bigger, and defendants decide, I don't have a whole lot to lose by just trying this case. And you've got plaintiff counsel who may be, sure enough, excellent at negotiating class terms, but bluntly, they haven't seen a courtroom in quite a while.
Right.
So yes, there is a definite need for that on the plaintiff side too.
Thank you. I wanted to just ask David and Frank before we move on to the next slide. I see on here, informal discovery. And to me, as a mediator, and I did this when I was in private practice, one way to build that settlement relationship is, under the wrapper of the confidential mediation sessions, the parties can get to the meat of the matter, can engage in an exchange of data information without some of the problems associated with the formal discovery process or having to go to a magistrate or a judge for a ruling, and the mediator can help facilitate that exchange so that the party, have you seen that in your practice? I know, Frank, I've seen it just from the cases I've worked with you on.
Oh yeah, the tip that I would give to any defense lawyer out there is, after you've tell your client to notify your insurance carrier and send out the preservation memo and start your internal investigation, one of the first things you need to do is call the plaintiff's lawyer and establish a rapport, take their temperature, find out what they're looking for, listen to them. Sometimes a class action gets filed and your initial reaction to it is, this is Rule 11. And you're missing something about the case, either because it wasn't pleaded the right way or just because you missed it. And listening to the plaintiff's lawyer is basically free discovery, first of all. Second of all, you will narrow the issues immediately. You'll know right away what you're really going to be litigating and what you're not going to be litigating. And then most importantly, you are going to be identifying a case where you may need to call your client and the insurance carrier, if there is one, and say, guys, we need to resolve this. And let's do it now before you've paid my firm $1 million, which means you're probably going to end up paying the plaintiff's lawyer another $1 million on top of everything else that's happened. In the case, we can get out for something reasonable now. And, I've got a couple of experienced class action mediators that I've worked with 100 times who are very well received by the judiciary. Let's start this process now. Now, you have to be careful. The clients don't often want to hear that.
Yeah.
They a lot of times want their lawyer to be a warrior and telling them everything's going to be okay. But, you have to have those conversations sometimes. And if you don't make that initial call to the plaintiff's lawyer, not only will the plaintiff's lawyer and you maybe get off on the wrong foot, with the first communication being your responsive filing to their complaint. But you'll also be missing an opportunity, because there really is an opportunity there. And if you are the experienced one, which is often the case with me, and the plaintiff's lawyer is less experienced, it's an opportunity for you to start laying the groundwork for what the moving parts need to be in a class-wide settlement. So for all those reasons, I think it's absolutely critical to establish the relationship. Otherwise, what's going to happen at some point along the way, your client's going to pay more money than they should have. And that's when you get settlement counsel brought in, right? That's when things start to get out of your control. There's a procedure, Lance, up in West Palm, they always send you to see the magistrate, right?
Right.
In every case I've had up there, you always have to go see the magistrate and have an informal mediation. And they do that a lot of times early on in the case. And to me, that's one of the most valuable things, because not only do you get to have that conversation with opposing counsel, but you also get to see them in person, and you get to establish a rapport.
Exactly.
So it's incredibly important in any case, but particularly in a class action where the stakes are so high and there are so many moving parts, and there is strict judicial oversight, and there are a lot of ethical issues that you need to be mindful of.
Indeed. And well said, Frank.
Vince, and on this screen, the last box on the right, momentum management, is an important thing, because in every piece of litigation, you have ups and you have downs, and you have moments of high-level adversarial issues going on. But if you can get a mediation with a mediator, an active mediator, the pre-mediation that goes on, while in a typical case, non-class action could be 2 weeks out, In a mediation on a class action, it could be 6 to 8 weeks out. And the earlier the better, and not only initiate the management towards a resolution, but maintain it. And that's the key issue, to keep that train going in a constructive way. And that's the responsibility that the mediator has for both sides. And
Well,
some,
yeah, the other moving part there, I don't want to dominate this, but it's important, is discovery disputes. You can spend in a class action 80% of your defense spend on class discovery if it's not managed properly. It can get out of control very quickly. It becomes a runaway freight train. The magistrate hates you, the judge hates you, your client hates you, and you're stuck in this quagmire. It's like quicksand and you can't get out of it. And you can avoid a good chunk of that discovery by having those early conversations. Maybe you stipulate to numerosity, for example. Maybe you agree that you're not going to contest one of the other class action requirements. You can narrow the issues, but most importantly, you can a lot of times avoid a motion to compel, which, in federal court is full. Well, it's not so much full briefing anymore, but for the longest time, it was full briefing and then a hearing, and then maybe an appeal to the federal judge. And all that can be avoided if you can establish that rapport early on.
And again, if I just can weigh in on that too, Frank, that's an excellent point. And it's a different approach from what some defendants out of the box, as you say, they want to put their warrior cap on and then file a chudasama motion to stop all discovery, get our motion to dismiss heard first. And then if that doesn't work, try again. And, what you're suggesting is a more, strategic approach to what's in your client's best interest, which may be an early resolution on terms that are favorable, or spending money where it's important, but not wasting money on unnecessary discovery disputes that could be avoided.
And Lance, I would add to that, to echo what Frank was saying, just taking it reversing it on the plaintiff side, using the relationships via a mediation early on. Because as plaintiff's counsel, contrary sometimes to what corporate defendants may think, who are inexperienced with class actions, we don't have any desire to litigate for 4 years a class where numerosity was a tenth of what we thought it was, or that there are serious monetizing issues from the defendant, or that there, a number of things like that. If you can find out early on, I was telling Frank this earlier yesterday, we were talking, I said, it's sometimes frustrating to have inexperience on the defense side, and see this a lot of times, with counsel that gets hired, by an insurance company, they haven't had class experience before, and you're trying to tell them early on, look, your client's saying they want to resolve this case quickly. We appreciate that, but there's certain things from a due diligence standpoint, from a due process standpoint, that we still have to do. I can't go before someone like Judge Proctor and say, hey, we're satisfied that this covers all the class members and it's X number. Well, counsel, how do you know that? Well, defense counsel told me. Right? And trying to convince them who don't have the experience to think, well, you guys are just wanting to fish for more information. You're trying to make more of this than what it is, and not understanding, no, we're trying to get to an early resolution.
Right.
I don't need to take 4 depositions to find out how many products you manufacture that might fit within this class definition.
Or that don't fit. Right. It's oftentimes the opposite. Why play hide and seek on whether or not the state's class recovery is adequate or whether the claims apply to that state or those category of if the defendants don't ever share that information as a plaintiff's counsel, you're litigating in the dark until you figure it out.
Well, and you have a fiduciary obligation as a plaintiff's lawyer. You're representing a class of people who aren't even before the court, and so you need to do this due diligence. And as a defense lawyer, I routinely remind my clients, this is not an individual case. And so if think about it as a car analogy, they're not going to buy the car without kicking the tires, right? I mean, it's that simple. They have to know a little bit. And I tell clients all the time, a little upfront or informal, not involuntary, informal discovery can go a long way. It really can. First, it shows your good faith. Second of all, you're just being transparent. But and it does narrow the issues. But at the end of the day, you are now giving the plaintiff's attorney what they need to be able to represent to the court that they have done their due diligence. And when you layer on a right to confirmatory discovery on the back end,
Right.
and to audit any settlement fund administration, now a judge like Judge Proctor is going to be much, more comfortable with agreeing that, okay, we're going to take away some of the due process rights of all these people that aren't before the court, because that's ultimately what you're doing on a class action settlement. And so,
Right.
it's important for the practitioners to understand that that is a fundamental difference between class litigation and individual litigation.
Well said, Frank. Thank you. Kathy, let's go ahead and take a look at the next slide. Okay, so that's a perfect introduction to here key mediation techniques. In other words, what techniques have you found that are effective? What sorts of procedures can be put in place, to evaluate, the merits of the case, whether or not the case is going to get settled, on what terms are going to be settled. Rod, why don't you lead us off with your insights on what works for you and how to go about it?
Well, thank you, Lance. And I think the key is initiating these pre-mediation meetings, whether they're by phone, over Zoom, or in person, and evolving. If the defense is ready to receive a demand, now let's talk about what that demand should look like. Not so much in terms of what the numbers are. Obviously, that's where everybody wants to get, but you've got to evolve a structure. So a structure has got to be identified in terms of the mechanisms to getting that. That may take some pre-mediation dialogue between the two sides, but at the very least, if they're ready for it, let's get that structure out there ahead of time, because it's based on that as you go down the path of what you've got here, from demands to evaluations. It's all shaped around, well, what are we talking about? And what other prior settlements are there that we can look to the precedent of that can define what's in an area of reasonable, as opposed to just being way high or being way low. So the demands that don't carry necessarily a number to begin with, but the demands that carry a structure and a mechanism to evolve the structure from pre-mediation into the mediation and then the resolution.
Rod, is it your practice in terms of the structure, to encourage the parties to circulate term sheets to each other that outline what the structure is, and they can fill in some of the data, the amounts, but at least we can know what the structure looks like, what the deal points are, what we need to negotiate. You found that to be helpful?
Absolutely. And many times the defense says, well, Rod, I need to know what they're talking about. So
Right.
you talk to the plaintiffs and say, let's explain what you're talking about. Is this going to be a common fund? Is it going to be a claims made? Is there going to be any reversionary or not? Absolutely not. We're not going to have any reversionary. But the point is to get it on the table early and to evolve it, because the value of a case is really not just the number, it's the structure, the context within that number. And if it can be evolved in the pre-mediation, before you have everybody on the screen involved in that day or two, you can make a heck of a lot of progress, so that when you do get to the table that day, night or two of negotiating, you're negotiating numbers, concepts. You don't need to negotiate the structure. So the earlier, the better. Most of the times it starts with the plaintiff, but there are times the defense has in mind what this structure is, and so they can put it out there, again, without a number in it, but certainly with the structure identified.
David, is that how do you typically, begin your mediations? And did you circulate term sheets? So tell me how you how you get into resolving your cases?
Yeah, so have done both ways, and a lot of that is somewhat mediator dependent of what whoever is media prefers the parties are doing if they ask for it. You know, one I have had, I go back to this, the non-monetary issues.
Mm-hmm.
We had one recently where, had a term sheet possibly been exchanged early on, we could have avoided kind of what was an explosion over a non-monetary issue that was a big deal to the defendant, whether we thought it was right or wrong. It was a big deal to them. Had we and it was something that we had a difficult time agreeing to, but we could have headed it off and saved a lot of wasted energy, if you will, if in that situation there was exchanged term sheets. Because had we gotten that early on and they said, hey, this is what we want, we could have addressed it. I think the other thing, Lance, is I always say this, we kind of preach this, and that is, first and foremost, just concentrate on the end goal with your settlement terms.
Mm-hmm.
That, again, putting aside the monetary part, but concentrate on the terms that will secure approval as required under Rule 23. I mean, concentrate on those terms, because both parties want approval and the court wants approval.
Right.
Look in your, early on, look at what you can anticipate, and this is where both sides can talk of what's going to withstand objections and appeals.
Lance, can I jump in on this?
Please, Your Honor.
The last 5 years or so, I've presided over a number of class actions, but 3 come to mind. I'm not going to name them, but all 3 involved settlements of either 9 or 10 figures. In each one of those, that amount of money on the table, my direction to the parties, and you asked earlier, how can the court be involved? I said, I don't want you to talk about money to start the mediation. I want you to work on a term sheet and on the non-monetary terms. And I want those all nailed down before you even exchange a dollar figure. And that did 3 things in my opinion. One, to David's point, it knocks out a lot of the things we're going to have to deal with before we get to things that we want to deal with. Second, to Rod's point earlier, that's momentum management. Mm-hmm. If the parties can start seeing wins and getting the ball in the end zone on non-monetary terms, it builds momentum and also creates some incentives. We can get this done. We can negotiate hard things and come out on the other side with an agreement that's a give-take. And third, I think it really informs the monetary figure, because one lead lawyer in one of these class actions said to me at the beginning of the case, this case is either going to settle for extraordinary industry-changing non-monetary relief, mm-hmm. and a more moderated settlement for the class, because the non-monetary relief is more valuable to us, or it's going to be something that we're going to have to continue fighting after this settlement about the non-monetary aspects of the settlement, and a big check's going to be written to these class members. And if I'm the defendant, I'd rather pay less and come up with a plan that helps me manage the industry, manage my business practices, my business plan going forward. Mm-hmm. So I think that accomplishes 3 things.
Mm-hmm. And those, thank you, Judge. And those non-monetary terms are often, if you flag them, as David said, up front and include them in the discussion early, they can have tremendous value in terms of forming, as the judge said, that settlement relationship, finding the momentum where you are able to reach agreement on some of the terms that you can knock out, potentially. And they add value to the settlement.
And again, coming beside Rod on a point he made earlier, there's a sliding scale in these cases about what the best strategy is. But huge cases, I think you can deal with a lot of those non-monetary terms in pre-mediation discussions with lawyers. And when it's a big deal, I think those need to be nose to nose. They can be caucus sessions where it's just one side with the mediator and then the other side with the mediator. But the mediator is starting to see how the Venn diagram might fit together a little more closely, and there could be some overlap in the positions there. And I think that's a big win if you can get that in place.
Thank you, indeed. Kathy, let's move on to the next slide because I think that's a perfect segue. And this does take us into the heart and the meat of what the judge was just referring to, these non-monetary injunctive terms, which can be very critical to the defendant, can add value to the settlement. When you get into the meat of these resolution discussions, Rod, how do you approach taking a look at the actual drafting and when you get down into the fair tax of
Right. Well, what I mentioned before about creating these structures, creating these agreements, allowing them to be evolving from the beginning all the way through the process. And there are some that can be identified as you have 1 through 6 on your screen. But for instance, number 5 should be left blank. I mean, totally left blank. There should be no fingerprint on a suggestion of what that is, while the focus is on the meat of the substance of this resolution. And if you can begin to evolve that, the attorney fees will work in its place. The one, and it was back on your last slide, there is a high level of transparency in class action mediation. You've got a wealth of settlements out there that are visible, that are known. Why are they known? Because they're approved publicly by the courts, and so they stand as precedent. Now, there's a lot, some people think case A is what takes place here, and some say, no, it's B, and some say, well, how about C? But whatever it is, there's ways to compare it, some ways to distinguish it, and some ways to evolve what you're dealing with here based on the facts that you've got. So under the timing issue, which I realize is perhaps something for fees to be at the end, you can begin to develop payment, release, and injunctive terms, keeping an eye on the concept of objectors. We share the vision that nobody wants objectors. So let's clear the way. And what was acceptable to a court in one case, maybe it is and maybe it isn't in this case, but the precedent of it can help evolve this mediation agreement to be solid as you get to the end.
I have objectors on that, Rod, but many times there are other lawsuits. There could be, David, other plaintiffs' cases out there. Someone could have filed over you. You could have different plaintiffs groups that are, working. Do you try to wrap the other lawsuits into your resolutions? How do you handle that in your experience, David?
In my experience with that, and we've had that, and a lot of that is kind of defendant dependent, if you will, of what they're, if we can avoid having to bring more, so to speak, chaos into it, we will. But if the defendant is insisting on, hey, we've got these, 3 other cases, the best example I can think of a lot of times is where we have filed state-specific class actions where the theory and the defendants are one and the same, but they're just repeated in other states, and the class size, if you will, is limited to those states.
Right.
And the defendant comes and says, hey, we want national peace. We really don't want to keep repeating this in every state. It's very obvious you guys are going to keep filing these. Can we do that? Well, then it becomes, you've got ABC plaintiff firm that's got 10 states. You've got another plaintiff's firm that's got 5 states. Some states have more class members than others. And, so can you all come together and say, you know what, if the defendant wants to figure out a way to get national relief and we need to be creative here, you sometimes have to work. You're sometimes forced to work together, right? Whether you like it or not. And let's just call it like it is. What it comes down to is, on the plaintiff side, you're worried about who's going to get stuck with having to do the most work to bring it together. And is that firm or person going to, in turn, be paid for that, so to speak? So that's the biggest thing I've seen in that at that level.
And that also could involve drafting. You might have to draft to include other states, to include these other lawyers, as you get closer to the finalization of the settlement.
And Lance, and
Yes,
that involves the ability to deal with the scope of the relief. In other words, is this a statewide matter? Is it multi-states? Is it nationwide? And I think it was Frank who said it before. The defense wants the broadest possible release. Great. So we've got to shape it to make sure there's nobody left out. And yet, obviously, you've got to incorporate those who are prosecuting those, or if there's an absence, then the plaintiff's attorneys that are with you have got to be willing to expand it to those areas.
Let's go ahead, Kathy, and take a look at our next slide. We only have a few minutes left. Okay, so I think David and Frank have both mentioned that there are some new lawyers who are getting into this space and may not necessarily always know how the ethical issues unfold in class actions as opposed to some of the other types of cases that can be brought and prosecuted. So I wanted a slide here for ethics issues so that I could ask our esteemed panels some questions about how for example, attorney's fees get negotiated in a class action, and what's the ethical and proper way to discuss some of the issues that, for example, objectors or other cases that have been brought. So I'll open it up to whoever wants to take a stab at.
I can jump in, Lance, on this point, just because we had that very famous case in Miami, and I won't mention the names of the people who were involved, but the lawsuit against the city of Miami, where there were 7 lead plaintiffs, and the plaintiff's lawyer, who was a very, very accomplished, very well-known lawyer in Miami, negotiated a very large individual settlement for each of those lawyers, along with a very large fee for himself. And the class claims were dismissed. And that the outcome, without getting too deep into the weeds, because it is a very interesting rabbit hole, but the outcome is that the lead plaintiff's lawyer was disbarred. And some of the defense lawyers in that case disciplined. Everybody had egg on their face, and it was completely avoidable. I mean, at the end of the day, the number one rule, and at least from the defense standpoint, again, to all the practitioners out there, if the plaintiff's lawyers, when you make that initial call, says, hey, let's talk about my fee, you need to say no, and then you need to document that in an email or a letter. We can't talk about fees until we've resolved all of the class claims. That is a key issue, because remember, as a defendant, your audience is not just the judge in your case or cases. If it's a CAFA case, you're going to have an attorney general who's going to be looking at that, because you have to give notice to the attorney general after the settlement has gotten approved. Okay. And you may have other concerns with other kinds of regulators in individual states or at the federal level. And so you really need to take this seriously. This is not just a bunch of people pontificating or window dressing. This is the core of class action litigation, because the temptation is so high to give the plaintiff's lawyer extra money in return for basically sacrificing the absent class members and their due process rights and their recovery. So we see this all the time, with people who are not experienced. Sometimes they get offended. And in one case, Rod and I got thrown out of a plaintiff's lawyer's office in Chicago for saying this. But it happens, okay? You have to toe the line. You can't talk about fees until every single class term has been resolved. That is just a non-negotiable rule, and it goes along with everything else that's on this slide: the transparency, the settlement integrity, the arm's length negotiations. But to give an example, if we have a mediator who's not very experienced in class actions, you may find, and I've seen this many times, you may find the mediator suggesting that you try to resolve the fee first, right? I mean, this actually happens in my practice on a fairly regular basis. So I think this is probably the most important thing that you can walk away from the seminar today with, which is in class actions, there are ethical minefields. And this just underscores the point we're all making, which is you need to have experienced practitioners handling, or at least involved in handling these cases.
Yes, which, Frank, you're picking up on that. You can then, at the point of getting the substantial material terms concluded, you could request, whether from the mediator or the party, someone's an email that suggests, as of 3:45 on the afternoon of May 29th, we resolve those issues, and we're going to proceed thereafter to discuss, and so that it's documented. It's there as a part of the process.
Well, I would say, to Frank's point also, and again, just flipping it around, we talked about this some collectively together yesterday, and that is the inexperience on both sides, right, can create this problem. I mean, this is within the last 12 months, very small statewide class, where defense counsel calls me up and says, hey, my client would like to resolve this quickly. I don't think this is going to be a large class, much to your disappointment, but here's what we're willing to do on fees. To which I said, we can't have this discussion. I mean, that's not the way. And, I felt a little bit, but I had to document that because, I wanted to make sure that, I didn't raise that. And I'm telling you now that, we can't discuss that.
Right.
I'll tell you another thing we have done before, like in some of this kind of goes back to the term sheet issue and early on and I think plaintiff lawyers ought to agree to this more often. They don't like doing it, and it can be a little draconian sometimes, but having your term sheet, the part of the effect on the settlement is that the parties agree, that any rulings of the court regarding the amount of fees, the cost and expenses, or the amount of any incentive award are related to, they agree will be considered separately by the court, number one. And then secondly, that any adverse ruling doesn't affect all the other terms of the settlement, so that no one can ever say, well, the only reason you wanted this was dependent on if the award was XYZ.
Right.
No, that doesn't even matter, because we have language within the settlement agreement and then within the approval pleadings.
Severability clause.
Yes.
Yeah,
I was going to say there's one item that I think is worth mentioning, and there's an MDL formed recently about it. That's claims administration issues. There's an MDL in front of Judge Bates up in DC.
Yep.
And that's an area where transparency is a big deal. I would commend this advice to anyone on both sides of the V. When you get to preliminary approval, you ought to have, in large swaths, your settlement claim administration plan ready to present, agreed to, ready to present, and approved then. The old days, we get the class settled and we'd go figure out how we're going to distribute the money later.
Right.
These aren't the old days anymore. And I think I told the lawyers in that MDL, I was able to talk to some of them recently, and I said, you got a real good shot. The defense, the plaintiffs counsel, defense counsel have a good shot to kind of reset that whole area. And I think that would benefit everyone if they could have some guidance going forward about how they're going to do that. But I take it I'm supposed to talk about judicial scrutiny of settlements now?
In the minute or two we have remaining. Yes.
Right.
Judge.
So just 2 or 3 things then. I'll be short. Any differences between the settlement class proposed and the settlement definition in the original pleadings or amended pleadings should be explained when you take your settlement in. Same thing if there's been a certified litigation class and there's a difference now in the settlement class. You're going to need to explain that. To my point I just made, the proposed allocation of the settlement fund ought to be disclosed early. The class recovery, if the plaintiffs had fully prevailed compared to what they're actually going to get, there ought to probably be some evidence to present to the court and an explanation about why certain cents on the dollars are part of the settlement, the risk of future litigation of both sides, those type of things. I think your plan for data security on how this is all going to be handled going forward. So some things that may be off the beaten path that you don't think about. The Northern District of California has an excellent document that they require their class lawyers to follow. And if you want to access that, it's on their website that lists a lot of the things that you ought to be considering for preliminary approval. That's the ball game. If you get preliminary approval done and it's front loaded and everything's in place, then in large, not always, but in large measure, all you're dealing with after that is going to be objections, if those are made.
I think it looks like thank you, Judge. It looks like we could probably continue this discussion for another 3 hours, but it looks like we've reached the end of our time here. Thank you all for joining us. I want to thank the panelists, Rodney and Judge Proctor, David and Frank. Thank you guys sincerely for sharing your wisdom and experience. The Florida Bar course number is 2605355N. I'm going to repeat that. The Florida Bar course number is 2605355N. And hopefully you can sign up and get your CLE credits. I believe also in Alabama. Kathy, am I correct about that?
Yeah, yes. The Alabama attendees need to take a survey, and that'll be linked in the follow-up email on Monday.
Thank you. Please join us for our upcoming webinars, all of which are free and all of which provide CLE credit. And thank you all for joining us. Have a wonderful Friday. Have a wonderful weekend. Thank you.
Thank you, Lance. Thanks for your leadership.
Thanks, guys.
Thank you. Thanks,
Good to be
everybody.
with all of you. Take care.
Bye.